A trio of New Hampshire Supreme Court justices heard arguments Tuesday morning for and against a November 2023 Superior Court ruling that the state must drastically increase education base adequacy aid by more than $500 million a year.
And the overwhelming evidence is that the state's funding of base adequacy is woefully inadequate.
The New Hampshire Solicitor General argued the ruling was an overreach that should not be affirmed.
You start to constitutionalize, or in a sense micromanage through the Constitution, how the legislature can structure and fund this system.
Justices pressed the state on that contention.
What is the remedy for a school district if that right is not observed by the legislature?
The remedy should be consistent with what a viable legal claim is, which would be a declaration that there's not enough money to meet the obligation in the system, and that the legislature would need to go back and fix that.
Asked about the court's role in this process on Close Up over the weekend, Senate President Sharon Carson didn't mince words.
Do you think the courts can dictate to the legislature what should be spent on schools?
No. Absolutely not.
The GOP majorities here at the State House appear intent on defending their legislative turf. But attorneys for Conval and its co-plaintiffs say the people of New Hampshire have a constitutional right.
Part 2, Article 83 has enshrined a state-funded right to an adequate education since 1791, and it's the court's responsibility to enforce those rights, just like the right to freedom of speech, the right to counsel in criminal cases, any other constitutional right.
A ruling is expected sometime next year. In Concord, Adam Sexton, WMUR News 9.